Welcome to Dad Talk Today. The podcast for dads facing some of the toughest moments of their lives. We are here to walk with men through divorce, keep them connected to their kids, help them understand their rights, and work for change in family law courts. Moms, you are always welcome too. We are all about advocating for shared parenting and doing what is best for our kids. Here is your host, Eric Carroll.
Good evening, everyone, and welcome to Dad Talk Today. I'm excited to be back. It's been a while since I've been on, and I'm really excited to be here with Kevin Hickey. Kevin, of course, is an attorney in Arkansas. I'm an attorney in Alabama and Florida, and so we're going to take your legal questions tonight. And, of course, you guys, you watch us all the time. You know that us answering questions for you does not create an attorney-client relationship. We get a lot of questions from other states, so we'll make sure that we clarify. You know, the laws are different in every single state, so we can give you our ideas and opinions and some legal advice if it's within our state. But just know that it's just that we can't give advice in all 50 states. So I'm excited to be here. Kevin, how are you doing tonight?
I'm doing great. How are you?
I'm doing great. I'm really excited to doing this with you because it's always great to have two attorneys on. Just like we were talking briefly beforehand, there's always different perspectives. We've had different experiences. Of course, things are different in different states. So we'll try to give you guys a really well-rounded opinion as to answer your questions. So I'm really excited about that. So, we had some questions earlier, and the issues of GALs comes up a lot. And the GALs are often, a bane of my existence in some of these cases because it doesn't seem that they're adequately trained. In fact, in my experience, most of them are not adequately trained. And in some states, you have to be an attorney. Like in Alabama, you have to be an attorney to be a GAL. In Florida, you don't. What is it like in Arkansas?
It's the same. You pretty much have to be an attorney in Arkansas. And my experience has been mixed. If you get and they're called attorney ad litems in Arkansas, if you get one that's not really being thorough with the case, it can really be a problem. If you feel like you're having to bring the ad litem along in your case, it's tough. But we have a handful of good ad litems. I always try to get them appointed on cases because I know they'll be thorough, they'll be fair. But yeah, it's, I try to explain to clients when you get an ad litem in the case, you're almost putting your case in front of them as much as you are the judge a lot of times. And don't you hear a lot, from maybe other attorneys, they tell their clients or they say, look, you just don't make the GAL mad. I hear, people say that all the time. Other attorneys tell their clients, whatever you do, don't make the GAL mad. So it's like tiptoeing around the GAL because sometimes I think that the judges appoint GALs because they just want somebody else to make a recommendation to make it easier for them to make a decision. So, and it shouldn't be that way. You shouldn't be worried about making the GAL mad. But let me ask you this. So, you have to be an attorney in some states. What is the reasoning behind that? Because attorneys have no special qualifications to make any decisions about what's best for kids than does any other layperson. So what do you think the reasoning is behind that? Well, as far as having ad litems, I think that the courts years ago decided that they wanted the children to have an advocate as well. And I think that was the initial plan. But an ad litem has a lot of power that an attorney representing one of the parents doesn't. They have a lot of authority to be able to interview people. They can interview your clients without you being there. They can interview the children. So they have a lot, and they can go and interview teachers at the school and counselors, and they can do a lot of things that you and I can't do unless we do a deposition or the other party's present and their attorney or something like that. So they have a lot of power, and if one is in your case, all I can do and try to do when an ad litem's in our case is give them all the information we can, make sure I stay in good communication with them, consistent communication so that they have everything they need. And just, like I said, try to argue. It's almost like when they get appointed, you are starting to argue your case as much to them as you are to the court.
Yeah, I agree. So the issue came up earlier, I think, is one of the Facebook comments about reports, GALs writing these reports. So here's the thing with the GAL report is, as in my experience, the judges like reports because they like to base their decisions on something, but a GAL can be a witness, right? Just in this case, just like anybody else. So if a GAL files a report before hearing the evidence, there's a problem with that, right? Because they haven't heard the evidence yet, like at trial. But in your experience, how many GALs have their mind made up even before you get to a final trial?
Many GALs will get in contact with me and the other attorney a week or two ahead of time and send an email or do a phone conference and say, I want to tell you guys kind of where I am at this point. And I think the hope of that is that then the attorneys can talk with their clients and maybe reach some kind of settlement. So as far as an official report, we rarely get something like that in Arkansas, at least in the counties that I work in, unless a judge specifically requests one. And I would probably object if it was ahead of time. I have always told ad litem's ahead of time, look, I think that your report or your recommendation needs to be almost like a closing statement after all the witnesses have finished, all the evidence has been presented, because otherwise it's way too prejudicial to just give that to the judge or disclose some of that before you even get started.
So I agree. I think that reports are discouraged for that reason. You file a report with the court, then before the close of evidence, and then, of course, a good attorney, I think, would object to that report and say, Judge, I haven't even heard the testimony from all the witnesses yet, haven't even seen all the documents.
Well, they almost always have hearsay in them, for one thing, and then a lot of possibly inadmissible documents or photos or whatever. And yeah, there's almost always problems with it.
Absolutely. So let's say that at the end of the close of evidence, have you ever had a GAL who doesn't, or a AAL who doesn't give a recommendation?
I had that happen one time, and she gave us a little bit of a hint of that a couple of weeks ahead of the hearing. Said, I really don't know what to do here. And I may, by the time I listened to all the evidence, well, we took a break after both sides had rested, and she told us again, I'm just going to leave it to the judge. I'm going to make recommendations and tell the judge some of my findings and the issues I have with each parent and what each parent I think is very strong at and positive at. But other than that, I'm not going to give a recommendation. I did have that happen one time, but that's the only time.
So here's a comment, or children leading negotiations. We talk about GALs sort of acting like mediators, and GALs, of course, talk to the children. How much influence do you think the children's desires have with the GALs or the AALs?
I think it depends on their age and their maturity level. I think if they're teenagers and they seem to be pretty mature about things and think about how things are at both houses and give an opinion on what they want to do, I think an ad litem will give that a fair amount of weight. But when they're a lot younger, they're, especially if they're 5, 6, 7 or young, I mean, their ideas change daily. And the ad litems that I was talking about earlier that I try to get appointed on cases or request that they're on cases, they have a lot of experience. They've dealt with all ages of children, and they know kind of how to use information from children. In my opinion, I think they use it appropriately.
Well, that's good. I'm glad to hear that, because here in Alabama, I find them to be insufferable. I find them to be ill-educated and biased. Now, that's just Melissa. That's Melissa's experience. That's my opinion. So I'm glad that there are some in Arkansas that you find to be ethical and helpful, because that is rarely the case here for me in Alabama. So we have a question here. How do you address hearsay from a GAL?
I object to it. I'm sure you do too. If they're trying to get something, most of the ad litems I deal with, they act as if they are just a third attorney in the hearing. So we don't have, and I don't know if that's just from practice or policies around the counties here locally where I practice. They aren't trying to constantly get hearsay in. So I'm not having to jump in there a lot in those kinds of situations.
All right. So I had a case a couple weeks ago, and I get this filing saying, hey, Judge, we think a GAL needs to be on this case. No reason given. So I should email the opposing counsel saying, why would you do that? Why would you request a GAL? and why? What's going on that we need a GAL? Of course, within minutes, I think the judge granted the order and put a GAL in the case. But in what circumstances do you think a GAL is warranted versus not warranted? Because that's one more person in this case making recommendations that essentially tramples over the parents' rights to make recommendations. So when is it warranted and when is it not?
Well, I think if I feel like I'm representing a targeted parent in an alienation situation, and that these children do come and talk to my client, and my client feels like they're being genuine, they're opening up to them and saying, look, dad or mom, I want to come, I want to be over here. I've got to be out of that house. Mom's not going to let me talk to anybody, though. Sometimes I think that you can bring an ad litem into a situation like that and get the children to go talk to them. Now, I warn clients all the time, they may be telling mom the same thing over in the other.
Oh, yes.
You never know what a child's going to say. But especially if children are really, really young and can't really speak for themselves, and I think there's a lot of problems in that other household that an ad litem or somebody, I can't go in, you and I can't really go in into the house. But if an ad litem can, and if there are things like that are in a case, then I think an ad litem can help. Sometimes I will request one.
All right. I think I can count on one hand over the last 12 years how many times I've requested a GAL. And I requested one actually maybe last month. And this is because the father absolutely could not get the children to visit with the mother. And so, if we're sitting here saying, listen, we're advocates for shared parenting, we're advocates for kids, had a long conversation with my client, and I said, do you think they should repair the relationship with the mother? He said, absolutely. So the only way we could think of is to bring in a GAL to talk with the kids, hear their concerns, and then maybe make a recommendation as to how to mend this relationship. So, I think we get caught up as attorneys sometimes in wanting to win. So we have to understand, and we have to keep in the back of our minds always, that winning does not mean, hey, my client got full custody and that mom was there on supervised custody, supervised visitation.
And I don't know how it is in Alabama and Florida. In Arkansas, we have Administrative Order 15, and that's what governs the ad litems in our state. And there's a section in there that says the ad litem is required to tell whatever their recommendation is. They're required to let the judge know what the child's preference was if the child gave a preference. So if the child gave a preference, look, I really want to go to dad's, and the ad litem is not recommending that, they still have to let the judge know that, look, the children do want to go over there, though. And so I think that helps a little bit.
Right. So there's it says, but they say not to discuss any of it to them. Who says, so I'm not exactly sure what you're asking, George. So ask that again.
Ask it again. I think he may be getting at that you're not supposed to talk to the children about the case, and that's always problematic.
It's problematic. And so I had a case where the judge was saying, listen, okay, neither parent can discuss anything with these kids. I'm like, well, wait a minute. Why? First of all, why would you limit a parent's ability to sit and talk to the kids when there's so much contention and so much stress? And sometimes the best person to explain it would be the parents. Now, I understand that parents sometimes try to pull kids in one direction, but I think before a court enters an order saying you as a dad or you as a mom cannot talk about this stressful situation with your child, I think there needs to be a good reason why. So how often do you see where the judges tell parents that, hey, you can't talk to your kids about this?
Constantly. And they put it in the order, neither parent is to talk to the children about this case. And I have 2 or 3 judges locally that are really good family law judges, and that I can go and talk to about just general ideas sometimes, not specific, not ex parte specific cases. But that's one of the things that I've thought about talking with them about is, this admonition about not talking to the kids about the case. I think what you're getting at is, don't go in there and say, let me tell you about the motion dad filed, or let me tell you about the motion or what he said, or I get that. That's not helping anything. But when the child comes up and says, what's going on? I don't think it's very fair to the parent or the child for the parent to have to say, well, the judge said I can't say anything to you. There's got to be something that can be talked about that's not damaging and not alienating and not harmful to the legal process to be able to talk to your children about it.
Right. I agree. Here's a good question. It was more of a comment, I think. No offense to you both as attorneys, but how are attorneys qualified to perform these tasks when some have no children, others not married? Are there some court systems that qualify citizens or peers to be GALs? Both of my GALs were overworked and uninterested in doing a thorough job. So, you know what, Jason? I agree with you. What the heck qualifies a lawyer to be a GAL? The answer is nothing. There's nothing that says just because we're attorneys doesn't mean that we're qualified to make mental health judgment calls or to make a judgment call on who's a better parent at all. So, and I think you're absolutely right. That's a good question. I don't think that it can be answered. Now, remember, in Alabama, you have to be an attorney. Like in Florida, you do not. And Florida actually has a pretty good GAL training program. But Kevin, that's a good question. What qualifies us as attorneys to make these decisions?
Well, Arkansas has a good training program too. And I think it's a 3-day program. It's 8 hours a day, something like that, for you to get certified. And they do talk about a little bit about children's psychology and that kind of thing, and how to talk to children, and what your role is as the ad litem. Now that's in 3 days. I mean, that doesn't replace the knowledge of a parent that's had a child for years and years. So other than that, that's the qualifications. And you're right. I mean, an ad litem's never going to know your children like you do. Or like a parent would that has children. Even if that ad litem does not have children, they're just not going to have that knowledge. So I mean that's the answer. I mean, you've got an ad litem. They have training on how to represent children, but that's many times about the extent of it.
Anyway, so in Alabama, there's training if you're working on the juvenile matter as a GAL. There's no training, zero training to be a GAL in a domestic relations case, like a divorce, something outside of juvenile court. So the only qualification for a domestic relations matter GAL is that you be a licensed attorney. So is there funding in Alabama and Florida for private ad litems? Like if an ad litem is appointed by the judge in Arkansas, a private attorney that's a certified ad litem, and they get appointed on a domestic relations case, a non-juvenile case, they can request funding from the state at the end of the case, and sometimes those funds run out. Does Alabama or Florida have anything like that? I think they both had something like that. I don't think in Alabama it was reinstituted recently, as of lately. In the DR cases, it is literally a private pay, and it's paying another attorney. Sometimes the GALs will cut their rates, and sometimes not, but it's another attorney rate. So if you go to mediation, for instance, I mean, some of these counties have mandatory mediation. Then you're paying your attorney, you're paying half the mediator's fee, and you're paying the GAL fee. So it's really not, I don't think it's something that's very feasible, but it's what they do. Yeah,
it's expensive in a hurry.
Yes, absolutely. So I'm going to show some of these comments real quick. I appreciate that. I think that's one reason that we really like Kevin is Kevin comes on here and he is transparent, because I think, those attorneys who work within the system and they fail to recognize and acknowledge the faults within the system, and we all know they exist, certainly don't do anybody any favors at all.
I agree.
Okay, so let's take this question. My son's mother is non-compliant with our court order for visiting, but the court will not do anything. What step should I take next? Okay, Patrick, I don't know what state you're in, but Kevin, you want to take a stab at that?
And you, I know you've been doing this too, Melissa. I mean, maybe you're getting these questions. We get these questions every week, and it all comes down to the judge. That judge has the authority to do anything from when a parent is in contempt of an order, they violated something in an order. That judge has all kinds of powers to punish that parent. They can anything from a slap on the wrist to say don't do that again, all the way up to putting them in jail. And there's all kinds of things in between there: fines, attorney's fees. You can they can restrict your visitation time. They can do all kinds of things. But sometimes judges, it just takes a lot to get their attention. I don't know what your experience has been, Melissa, but there are certain judges that I will start numbering my contempt motions. I'll say third contempt motion, fourth contempt motion. So maybe they will then see, oh, wait a minute, I've held this person in contempt 3 times before. Because, and I get the client's frustration because they just want the order followed. and they'll come in and tell me, look, I'm doing everything the judge told me. Why does he get to get away with not? And it can be frustrating.
It is frustrating because it does come down to the individual judge. And I think when we look at the shared parenting legislation that we're, taking to these different 50 states, like one thing that the judges really feel attacked on is their discretion. Like, but you're taking discretion away from the court. So here's the thing about justice is the law says, if I serve a subpoena and for these documents, you're served that you have so many days to get that back to me. That's a law. So if I don't get the documents and I go to the court and I file a motion to compel to get the documents, and there are some judges I know they're going to follow the law. And there's other judges that are not going to follow the law. For instance, I have a hearing coming up, a trial this Thursday. Opposing counsel, I'll put it on opposing counsel, but the former wife on the other side hasn't done anything she's supposed to do. She's been compelled by the court. She's been given deadlines. I filed what's called a motion in limine. Okay, that means you're like, listen, judge, they didn't comply. They didn't give me this, so they shouldn't be able to use this in trial. I come up with it at the last minute and try to use it in trial. So I file this. So I have this months worth of documented non-compliance, and I get a motion that says a response from the court that says, we'll take it up right before the hearing. So it's unfair. But which judges give this wiggle room and which judges will not. So if we're looking at the administration of justice, if we're looking at the law, at the very least, the people who come before the court should have some sort of certainty attached with this is the law. If I do this, if I act a certain way, this should be my result. Why is there so much discretion? Why do the judges have so much wiggle room?
Right. And it's frustrating. I mean, and it's hard to explain to clients. They don't understand it. And trial judges have a lot of discretion in family law cases. And that's just kind of the bottom line.
Yeah.
And I have had that happen too, scheduling a motion to compel hearing or even a motion to dismiss hearing on the same day that you're set for your final hearing or trial. I've never understood that. It's like, Judge, we have to prepare our entire case because if you deny our motion, then we're going forward. We got to prepare for everything. And I've never understood that.
Without a doubt. So we have a question from Michael. Can you bring a due process violation in your family matter to federal court?
The
answer is you can, but.
Yeah, I mean, you can file a 1983 a civil rights claim, but that's not in your family law matter. That may have arisen out of something that happened in your family law case. But yeah, you can file some civil rights actions in federal court regarding family law cases.
Yeah, you guys, judges have judicial immunity is strong. It's strong.
Oh yeah. Now I'm not talking about going after judges. That's almost impossible. But there are other things that can be filed.
Well, what could be filed if you're saying not against judge, and if it's a 1983 case, who else would you be alleging a due process violation?
Well, when I say a family law case, that would be if CPS got involved and took the children wrongfully. We've sued under 1983 in federal court for those kinds of things. You can't really sue another parent when you file a 1983 claim. I mean, you have to have a state actor, so you can't really go after a private person.
Right.
That is a big distinction. I don't want everybody leaving thinking they can go file 1983 claims against their spouse or ex-spouse. You can't do that.
No, that's the state actor. That's right. All right. Julie asked this question. My boyfriend's case is closed after his lawyer misrepresented him. He wants to open the case again with a new lawyer. We have had 2 Rhode Island lawyers tell us that orders can only be changed if there's a change in circumstances, which there hasn't been. They said you can't just reopen the case because you don't like the order. His kids won't even speak to him. Their mother has brainwashed them so badly. We need serious help.
Well, I think you got pretty good advice. Usually you do have to show a major change in circumstances. Every state pretty much has language like that, either substantial change in circumstances, significant change. Since the last time you were in court, and that's to prevent litigants from just coming back every 2 months trying to change something. Now, the last part of that question, it sounded like mom was not following the order or allowing visitation or something. If you can go back to court over something like that without a change in circumstances, that'd be more of a contempt kind of issue.
Right. And I think the last part of your statement also said the mother has brainwashed them. So, if you can prove some sort of alienation or brainwashing, then yes, that can be a change in circumstances. So I agree with Kevin. It might be more of a matter where, like you're saying, there's visitation that she's not complying with, or there's, sometimes the orders to say, mom will let dad visit with on Skype or FaceTime or whatever the case is. So if he's not getting those visits, well, that is also could constitute some actionable an actionable case.
Absolutely.
All right. So here's a good question from Timmy: is turning an attorney into the bar a bad idea?
That is, I don't know how to answer that. It can be a bad idea, but if you feel like an attorney has violated an ethical rule to an extent that they need to be reported, I think you may need, and especially if it was your case and you had major issues, that may be something you need to think about. I always tell people, maybe ask another attorney, set up a consult with another attorney and say, let me tell you what happened in my case. Can you explain this to me? That's how I would answer it, I guess.
His question too is, will it affect your custody case? Let me tell you, it could, because
if you're doing it while the case is still going on, I wouldn't do that.
It could. I've had cases where a client has come to me after filing a complaint against their ex-attorney, and the other attorney will say, well, judge, he just doesn't like the results. He went and filed a bar complaint against his previous counsel. And you don't know the relationships between the judges and these attorneys. You just don't know. So could it affect your case? I'm going to be honest. I think we both say it could. It
absolutely could.
But absolutely it could. So, all right, let me see. I'm trying to get through these here, you guys. Kevin can't see the questions, only I can. I'm not very good on this yet. I'm getting better. So, all right.
You're doing good.
So, and Timmy also says, what about attorneys not doing their job and representing you? So if you have people out there watching right now and they're saying, look, my attorney's just not doing their job, what course do you think they should take?
I tell clients or people that have called with those kinds of questions, I say, set up a time to go, not on the phone, go sit down with your attorney with your questions and ask why things are being done a certain way, not done. Why is this not happening? Because there may be a perfectly rational explanation for it. But if you don't like the answers that you're getting and you're losing confidence, then you may need to change attorneys. I hate to ever advise somebody to do that, but it does happen. But I think the first course of action is go sit down with your lawyer and get some answers to your questions.
Absolutely. So Knight Hancock is asking, what if you're denied discovery? So I don't know how it is in Arkansas, but in some of these juvenile cases, it says we have to ask for leave of court to conduct discovery. The vast majority of the time, I've had one pretty big case where the judge denied discovery. He was subsequently removed from the bench. But most of the time, the judges absolutely, if custody is on the table, they let you engage in discovery. But what do they do if they're denied discovery?
So you can engage in discovery in juvenile cases in Alabama and Florida?
Well, we have to have leave of the court.
Okay, so you get permission first.
Yes.
Okay, we can send, in domestic cases, we can send interrogatories anytime we want. We don't have to ask permission first. In juvenile cases, I started sending interrogatories to the state to have them answer, and we started getting objections. And now, and I never got to the point where, and I would file a hearing. I asked for a hearing saying they're not giving us discovery, and we never got to the point where we actually had a hearing. They would turn over the items I needed, not really as official interrogatory responses, but they would turn over the reports and the things we wanted. And so it kind of appeased us enough that we got what we needed. And so I haven't pushed that issue yet, but one state attorney told me about a year or 2 years ago, they didn't feel like they were required to provide responses to discovery. So I've never pushed that, though, to get an answer.
Oh, I got you. Okay.
Many times I don't know in the juvenile cases you handle, but they will put together court reports for us from the caseworker that basically says, and they have to give us that 7 days ahead of the hearing, everyone they talked to, what happened, what they said, why they're basing their decision on this or that. So we kind of get an idea of who their witnesses and evidence are anyway from that.
Gotcha. All right, Jonathan is asking what to do when the judge won't answer your motion to remove opposing counsel who represented me in a prior divorce.
Well, I think that needs to be answered. That sounds like a conflict.
Sounds like a bar complaint to me.
It could be. Judges are supposed to take action on motions within a certain amount of time. And, we did this in John Mass' case, months went by, and I was talking with the local counsel, and I finally said, look, I'll probably never be in front of that judge again. I'll be the bad guy. Let me write the letter. So I just wrote a letter and said, Judge, it's been 6 months. Can you give us an idea when you're going to give us an answer? And he gave us one the next week. But it's a little awkward trying to tell a judge how to do their job. But on something that important, that's something that needs to be ruled on before you go very much further in the case.
So you specified it was a previous divorce because, we as attorneys aren't conflicted out simply because we represented this person prior. So, for instance, let's say that I represented someone and I just did a deed, let's say, or a power of attorney that had nothing to do with the divorce. I'm not conflicted out necessarily because there's no nexus there that connects the facts together. But
I completely agree. I agree with that. That's right.
Yeah, but you said a previous divorce, so I would think that was something that the court needs to look into because the clock's ticking in the meantime. And if that attorney is disqualified, certainly it would affect the course of that case. So,
well, the risk you run is if the further you go through the case and have hearings, all of that could be thrown out on appeal.
That's right.
So you want to address that soon.
Absolutely. All right. Juan asked, how can you prove alienation to a court when the courts won't accept alienation as a legal term used in court? Also, what if a GAL fails to help bring forth major issues raised by medical providers of the safety of my son? Other major concerns were raised by social workers.
Then don't use the term alienation. Show the behaviors. A lot of judges get, I don't know, they don't like the phrase parental alienation syndrome. I don't know if they think it's junk science or whatever, but those behaviors are still out there and those behaviors are damaging. So just don't use those terms and focus on the behavior of mom or whoever's engaging in that behavior and show how it's harming the child and harming the time that the other parent is getting. That's all you can do. And as far as the GAL, if they won't introduce the evidence that you think is important, then introduce it yourself. The judge needs to see everything. And if the GAL doesn't think it's important, then present your case and show why you think it's important.
And I agree with Kevin. You guys, we can't throw around these terms like parental alienation. I think we throw them around too often and the courts can get desensitized to that. Problem number one. Problem number two is these experts out there, and I said that very loosely, they don't even know what parental alienation is. We have these therapists that come in and they say, oh, I've been this child's counselor for the last 2 years. And I think that there's no alienation by mom. So I say, okay, well, give me the definition of parental alienation. You get like deer in the headlights, like they don't know. Or you ask them how do you screen for parental alienation? Mm-hmm. So, or say, so you think that, you don't think there's no alienation here, but, or they'll say this, well, I think that a lot of this is just conflict between the child and the father. I think the father might be, saying things that he shouldn't say. Say, oh, well, how many hours have you spent with the father?
Mm-hmm.
None. Okay.
Zero. Yeah.
Zero. So that's another problem with using this term parental alienation is number one, they're overused. Number two, the experts don't have a strong grasp on exactly what it is. So you might have an alienation case and an expert might come in and say, no alienation exists simply because they're not versed on their own in exactly what that is. So, all right, Zach, I had a question. I'm currently going through the legal system with my son's mother. I have no criminal background and I failed a drug test for a medication I'm currently prescribed, but I was not when I took the test. Is it okay that she has not let me see him in 8 months? There's no court order telling her that she can withhold. Is this okay? No, but Kevin, what do you think?
I agree. No, if there's no court order, I tell clients this all the time. Your last order is in effect until it's changed. So if she hasn't filed anything, some kind of emergency relief because of your drug test or whatever, then that order is still in effect and she's supposed to be complying with it. And 8 months has gone by, it sounds like, and you need to get with somebody and get something filed.
Without a doubt. Yeah. All right. Tom says, what is the best reasons for the judge to approve children younger than 11 to be heard and talk to the judge?
There is some misinformation out there, and I guess every state's different, but I'll have clients come in and say, well, I know my children can't talk to the judge until they're 12, or I know at 12 years old they can decide where they want to live. Well, both of those things are false. That is total misinformation. A judge can talk to a child as young as 4 or 5 if they want to. The problem is, we all know what's going to happen. I mean, you're not going to be able to keep their attention. You don't know what they're going to say. You just can't. You're just not going to get reliable information from a child that young. So usually one or both attorneys will talk about or think about in strategy whether they're going to call children or not. Do you have an ad litem that's involved that's going to tell the court what the children have to say? If you don't, are you going to call the children? I largely leave that up to my clients. You put a child in a situation like that, it can be pretty traumatizing.
Yeah. And I get the question a lot, at what age can a child decide where they want to live? There's no age, at least in Alabama and Florida, there is no age. And the judge really doesn't decide at what age they're going to talk to a child or what child they're going to talk to. So, if I've had opposing counsel, at 4 years old, bring these kids in, like this little girl, gosh, broke my heart. She's on the stand. Her little feet were just swinging, and this little girl's sitting on the stand because opposing counsel wouldn't agree for this child to talk to the judge back in chambers. Mm-hmm. Right. So, but understand this, you guys, it's not always up to the judge. Sometimes, especially with alienated kids, like the teenagers, the really disrespectful ones, I don't agree for them to talk to judge in the chambers. I'm like, no, you know what? This kid here wants to be disrespectful. They want to be grown. They're going to take their butt up on the stand, and I'm going to treat them like they're grown. Okay?
Yeah, I can see that. In some cases, I could definitely see that happening.
Yeah. So, it's not always up to the judge, guys. Okay, Brianna is asking, in Florida, we are seeking shared custody. The mother ignored texts for over a month. Placed the child in a new school unknown to the father and traveling and sending the child with other family members. Is 50-50 shared custody something her father can be granted with granting his time back? It's been 4 months without his daughter.
Well, there's a lot in that question, and with it being Florida, I may end up pushing this one back to Melissa, but this is one of the reasons for shared parenting, because then one parent can't, the phrase I use, lord over the other parent by time with the children, using them as pawns. That's what shared parenting is about, is to try to equalize that power struggle that can sometimes happen and prevent the things that you're talking about there. So, yeah, I think if you hired me and we were filing something, that's what I'd be focusing on, is that, judge, we need more time and we need a 50-50 arrangement here, because mom is using her power too much to control this whole situation.
Yeah. I mean, if you have a parent who's frustrating the other parent's ability to have a relationship with a child, absolutely. I think you can petition the court and show a viable plan, show that it could be done. I know I have a case in Florida right now. Father's actually in Arkansas. The case is out of Florida, and he wants 50-50. Well, clearly 50-50 won't work, right? The mother's even said, well, you come back to Florida, we'll do 50-50. But just make sure that the plan that you have, that you offer the court, is something that's doable. And so I'm speaking from a men's perspective. I know, Kevin, you represent, I think, both men and women.
Right.
Women need representation, hands down. But I see a lot of pleadings that, dads will bring in from other attorneys. And I'm like, why would you even ask for this? Like, I don't know. That's what my attorney said to ask for. And then, they get shocked when the judge doesn't give them what they ask for. Well, it's not doable. You asked for full custody, but you're a truck driver and you're only home 1 week out of the month. How did you expect the judge to receive that? They're like, oh, I don't know. That's just what my attorney said to do.
Yeah. We have those conversations all the time in initial consults. It's what you're wanting to do won't work. You can't do 50-50 time when you're in Oklahoma and mom is in Florida. I mean, that's not going to work. But and sometimes you just have to have those conversations and talk it through to help them realize you're just going to have to come up with something else.
Yeah. All right. George is asking, how do you present proof of a narcissist ex-wife and yet the judge is being biased?
I don't know about that last part on the bias, but on the narcissism, you're just going to have to get some kind of a psychological evaluation done and present that to the court. And if sometimes when we get hired to take a case, there's already been psychological evaluations in the past, or the parent has already been getting some kind of therapy or mental health, and you can use those records. But you're going to have to show some kind of psychological information about it. You can't just go in and say he's a narcissist, and that's not enough. It won't work.
Yeah. So again, stay away from labels, okay? And not every judge will order a psychological evaluation. You can go and ask for one, but it doesn't mean that they're going to order one. So, you want to stay away from those labels unless there's a previous diagnosis, but look at the elements of narcissism, okay? I would recommend that you take those elements out and you detail for the court how this person is engaging in all these behaviors and how it's affecting you and how it's affecting your relationship to maintain a relationship with your children. Okay, because if you can't tie it in to the case and how it's relevant to the case, then they shouldn't, right? They shouldn't order a psych eval. Because one thing that I don't like is sometimes these petitions or these motions will come through, and they'll say, "Judge, we want him to undergo a psych evaluation." So I'll respond and I'll say, "For what?" Well, you can't just willy-nilly the court order somebody to undergo psychological evaluations. So there really should be some standard that we have to meet as litigants, right, before we're going to order someone else to undergo some sort of a psych eval. So, Kevin, in situations like that, how do you go about asking the court for a psych eval to where you have the best, chance for the judge granting that?
Well, you do have to show some history, not necessarily significant psychological problem history, but you've got to show there's a reason. Sometimes I've offered, you talk with the client ahead of time to make sure they're okay with this, but sometimes you can offer up your own client and say, "Judge, we really want the other side to have a psychological evaluation performed, and my client will do one too," and many times judges say, "Well, if they're both doing it, what's the harm?" But I want to go back to something you said a minute ago about be careful with labels and what people come in all the time. And the last several years, I've heard the word narcissism more than probably in my entire life. And you hear alienation and you hear PTSD and you hear bipolar, you hear all these things. And this is why you don't use labels. Last week, I took an opposing party's deposition that had put all this stuff in their motion that was wrong with my client. And under oath, I just asked her, "Okay, PTSD, you say he's been diagnosed with that. What evidence do you have of that?" None. She didn't have any. "Okay, you said he was bipolar, and you said that several times and have told other people that. What evidence do you have that he has been diagnosed as that?" None. That's what's going to an attorney that knows how to use that information is going to ask you about it, and then you've really hurt your case. So if you're going to throw those labels around, be sure that those diagnoses are really out there.
Yep, without a doubt. Got a question from Robert. What's the best approach to achieve 50-50 in a state with presumption that every other weekend is the best interest of a child? Hire expert witness, use studies as evidence, etc.?
Yes to all of that. I had, and this is so obvious, it's you just have to keep it in mind. We have a judge that I'm in front of a fair amount. She was put on the bench a few years ago, and I'll never forget, after she'd been on the bench a few months, she said, "Kevin, can I talk to you for a minute?" I said, "Yeah." She said, "I'm talking to all the attorneys that do a lot of this kind of work. There's a handful of you, and I just saw you today. You guys tell me what your client wants. Give me a schedule. Show me what you want." So my answer is put a schedule together and show why it works, and blow it up if you want to. Put it as some kind of a trial exhibit or something so the judge can see it, and explain why it'll work. I mean, sometimes the judges just want to hear what you have to say. It makes their job easier. And so keep that in mind.
Absolutely. Just did that one. All right. So Kimberly.
I want to answer one other thing at the last part of that question. I think they said, are there experts? There are experts that will come in and testify why a 50-50 arrangement is better than an every other weekend or something like that. So those kinds of experts are out there. You just need to search for them.
You need to search for them. I understand that they're expensive too. but you can search for them. And but you said there's a state with presumption of every other weekend. I don't think they would ever admit that. I'm not second guessing you. I know there's probably states that are still doing that because they get so much money off Title D and all these little Title IV incentives, right? But all the research that's available now, that given the case, that's pretty sad. All right, Kimberly, the head judge of my husband's case is Tarrant County. He attends the same church as the ex. How do you handle potential conflicts of interest? That in itself is not a conflict, but Kevin, describe what is a conflict and how they should handle that.
Well, Kim, if you sat down in front of me and we had this conversation, that's a tough one. And you would almost need to show, that they're having some kind of connection. Are they in the same study group? Are they, sometimes they have breakout groups after church, or are they in the same group on that? Or do they go to the parish hall afterwards? A lot of people will go out to eat afterwards. You have to almost show more connection than that. Now, if this is a 15-member church, you're talking about something completely different. But just going to the same church is not enough. And Tarrant County, I think, is Dallas or Fort Worth, somewhere. I think it's in that area. So if it's a bigger church, you may have a problem. You may have a problem showing a conflict.
So in Florida, there's a rule that attorneys cannot be friends with judges on social media, and that does not exist here in Alabama. But one thing that we do when there's a GAL, we look and see if they have mutual friends on Facebook. I had one case where we got the GAL disqualified. She was actually friends with the former wife on Facebook, and she was so, in my opinion, of my observation of her, she was so incredibly biased, but we were able to prove bias enough to the point where the judge said, yeah, I'm removed. So social media is a big source where you could look at to see if there is any conflicts, but I would think going to, just based upon the rules, going to the same church, that alone is not enough. So
I would agree. If you can find one other data point where they know each other or in another group, that might be enough.
Absolutely. All right. Timmy said, how do we use data research in court that 50-50 is better for the child, especially with a high conflict mother?
And this kind of goes to the question we had 2 or 3 questions ago about, are there studies out there? Yeah, there's a lot of great studies on shared parenting and the research and how much healthier it is for children. And you're going to find tons of great peer-reviewed articles online. The problem you're going to have is getting them into evidence. There are exceptions to the hearsay rule, like learned treatises, but you don't want to go to court without having had that addressed ahead of time. At least I wouldn't. I would want to know ahead of time if I'm going to get that into evidence or not. And by far the better practice is if you can afford some kind of an expert to come in and talk about those articles and why it's better, and the best practice, that's by far the best.
That is always the best. And let me tell you something that I do with my clients too, is I give them the research. They can read the research. I give them books to read. And one question I ask is, ask about the 50-50 schedule. This is what they're asking for. This is what they think it should look like. And coming up with this schedule, how did you come up with this schedule to think that this was to feel like this is in the best interest of your children? I've read books. I've read this book. I've read this article by Dr. Warshak. I read this by Dr. Linda Nielsen. And based upon my reading of that article, I believe that, and start spewing off what the article says. Okay?
That's a good way to get it in.
So if there's no other way to get it in as you educating yourself, becoming knowledgeable. Because number one, I think it looks really good to the court that you've taken this initiative to educate yourself on post-divorce parenting, right? Because I don't know about you, Kevin, but my experience, these judges, I think, hate dealing with divorces and especially dealing with post-divorce issues. So that's one way to get it in as well. Educate yourself, and then you testify as to what you've learned and how you're applying it to what recommendation you're making to the court.
That's great. Great point.
All right. So here we go. From Matthew. What can you do when your arrest record keeps being brought up even though you were never charged? Cases are closed.
Well, you've just got to say keeps being brought up. I don't know if this is each time you're going to court or just keeps being brought up and you're still in the same litigation currently, but I would at some point, I don't know if a motion in limine would be proper, but at some point you got to talk to the opposing attorney and say, look, we're going to have to either stipulate that he was never charged with anything. You can say he was arrested, but those charges never went anywhere. And that's what I'd be hammering on at the hearing, is that, yeah, he was arrested, but clearly the case was dismissed or never went anywhere.
Right. All right, Stephen, I haven't seen my kid but 2 times since it was born, and she did child support and didn't cooperate with them, and they closed the case, and now she's trying to get child support again. What can I do to see my kid and get some kind of custody?
Well, you've just got to file something with the court. I'm assuming paternity's been established since you're having to pay child support. But you've got to file some kind of motion with the court to get visitation, get some time. I don't know if I would jump. It doesn't sound like you've had a lot of time with the child. I don't think you need to be jumping straight to custody. I don't know that that's going to get you very far, but start getting more and more time through the court, through a visitation schedule.
Agreed. And understand this. There's a difference between an order to pay child support and an order establishing custodial rights and custody, visitation, things of that nature. Okay. So a child support order gives you the right to pay money, right? To pay child support, but it doesn't give you any other rights. Doesn't give you the right to visit, doesn't give you the right to make decisions, doesn't give you the right to, look at medical records, make educational decisions, nothing. And Kevin, I don't know how it is in Arkansas, but I know Alabama and Florida, a child support order is also an award of custody. Okay. Huge due process violation, huge notice violation, because when you get these child support papers, it says nothing about custody. Okay. But, whatever, they don't care. So that aside, when you get put on child support, it's also an award of custody for the mother, usually, which can make it difficult for you down the road. So to preserve any rights that you have, a lot of people think that you go to child support court, you automatically have rights. You don't. You have the right to pay child support. So I think you probably need to go see an attorney, whatever state you're in, so the attorney can explain the process, because getting custodial rights is completely different from getting the right to pay child support.
Absolutely. And a lot of parents and especially fathers that are paying, get confused by that. And they come in and say, well, they maybe start paying child support, but I didn't get any visitation. Well, they don't deal with that. All they will do is usually establish that you're biologically and legally the father, and then here you start paying. So anything else you want, you're going to have to get a private attorney to help with.
So, and a lot of dads, especially, I know, would go to court. They go to child support court thinking, okay, well, I'm going to tell the judge she's not letting me see my kid. So you get to child support court, you bring all your pay stuff, because that's what they care about. You give all your pay information, and you say, but judge, I want to help support my kid, but she's not letting me see my child. Judge says, different court. Okay, you got to go, take that to somewhere else. Sign off on a child support order. You're out the door. So exactly,
they won't deal with it. Yeah,
They won't. All right, George, is it best to go pro se or with an attorney?
With an attorney, for sure.
Depends on the attorney that you get, okay? Because there's a lot of attorneys out there who don't fight and don't believe in shared parenting, or don't believe in your rights as a dad. So make sure that when you go with an attorney, make sure you go with the right attorney, all right? Timmy says, can I pay you to find me an expert? I will pay you. Okay, Timmy. Here, and I think this is, and I brought up a few of his comments because I think you got some really good questions, but there's some experts out there, okay? So like, for instance, Dr. Linda Nielsen out of Wake Forest in North Carolina. She's an expert on like father-daughter relationships, and she's written textbooks on the matter. I mean, she teaches courses on it. So and Dr. Warshak, he's the one that took all these 110 studies, I think, combined them together. So there are experts out there. And I think, Kevin, you and I are probably more aware of like the national experts, but see if there's something locally, because a lot of times judges will trust the people that they know locally. It could be a matter of you calling some psychologists and just see, is this something that they do? But Kevin, how would you answer that question?
Well, I'm hoping he's got an attorney in his case too, and attorneys are usually pretty good at trying to find experts and networking with other attorneys with these kinds of issues. So I would go to your attorney first. If you're pro se, then I agree with what Melissa said. I think you're just going to have to do some research, maybe talk with some people locally, and it's depending on what kind of expert you're needing. What what exactly you're needing expertise in and needing this person to come testify about.
Absolutely. Hey, Brianna, is week on, week off shared custody in Florida when parents are under 12 miles apart and in the same county sustainable for a 4-year-old? Yes, why not?
I would think so, yeah.
Yeah. So, and again, but it comes down to, that's just a very small part of what the judge wants to look at, okay, is proximity. You know, you have a 4-year-old, so a lot of this is going to come down to the relationship between the 4-year-old and each individual parent. And this shouldn't be a huge consideration, but it is are the parents able to work with one another, co-parent with one another? Because sometimes you have one parent who intentionally won't co-parent, and then the court says, well, you know what, they can't get along, so I'm not going to do shared custody. And we all know the statistics on who generally gets custody in contested cases. But Kevin,
Right.
What is your opinion?
I really don't have anything to add. I think you said it perfectly. Absolutely, something. If the parents live that close, I don't see any reason it can't be done.
Absolutely. Okay, Tyler, why do courts not put more emphasis on the child's wishes? It's called the best interest of the child, and I've had multiple attorneys tell me judges don't like talking to children. My 7-year-old know where he is loved, and adults can be brainwashed the same as kids, just saying they're too old to testify accurately is wrong. So do courts put more emphasis on
Taylor? The reason, I think it depends on the judge that you have. And, you know, Melissa and I, we deal with different judges all the time. And many times, such as yourself, you're only dealing with one judge. So really, you're just getting that experience. But many judges, you have to really show them whether this child can come in and give credible, truthful information or not. And so judges will listen to the child, and then depending on their age, how mature they are, and how they come across when they're being questioned, they'll make a determination how much weight to give what they have to say. So I hear what you're saying, and I know it can be frustrating, but many times children are not, even adults are not reliable witnesses, but many times it's hard to tell. A child can go into court and say, I want to be with my mom so bad. And then the next day go and say, I want to be with my dad so bad. Yeah. And it's not their fault. They're not lying. It's just that they're children, and they have different thoughts on different days.
You know, they have different thoughts on different days, but understand this too, that most kids, especially the little ones, they have this desire to please. So they might say something to mom that they think mom wants to hear, and they might say something to dad that they think dad wants to hear. Kids get caught up in this process just like adults do, and they give conflicting information. So sometimes when a GAL will talk to a child when they're with mom, I'll say, well, wait a minute, but you need to talk to the kids when they're with dad too. And they can get a completely different version of the story when they're with dad.
That's right. That's exactly right. And then sometimes we didn't even get into if one parent's putting pressure on the children, or, oh my God, I can't believe you want to go to dad's again. Or, I mean, all of that, children feel all of that, and they catch that vibe, and they see it, and it affects the way they feel about things.
Absolutely. So, Evelina, do you have any experience with reunification therapy and co-parenting therapy with a high conflict ex? Does the therapist write a summary to the judge? Can custody be flipped due to such therapies? Kids are being alienated by ex's new spouse.
Well, this is a whole can of worms. Reunification therapy can be excellent, but it's hard to get it to work properly. And I've had some experience with it. We don't have it a lot in Arkansas. We have some co-parenting therapy. When you have a high conflict ex, and it's going to be hard for those things to work. You're going to have a lot of really tight parameters on how that's going to work. Because, let's say you go to reunification therapy for 90 minutes. That child's about to go home with one parent, and what's going to be said in the car? Is it going to totally undo everything that was just done? It's hard. I mean, it's great to try it, and a lot of times it does work, but I've seen mixed results with it.
Well, and I think here's the problem with that too, is you have different levels of alienation, right? In case
Yeah.
of severe alienation, sometimes the only thing you can do is remove the child from the alienating parent and limit contact until some of that brainwashing can sort of be undone. Now, but how many judges really want to say, okay, I'm going to remove the children from the mother and there's going to be no contact? Judges don't like to do that, but
Well,
unfortunately, sometimes that's the only
isn't
thing.
it Linda Gottlieb that has that program?
Linda has a program.
90 days, removing the child from that other parent for 90 in a severe case.
Mhm.
A severe case. And you're right. A judge is, I've never asked for that. That would be an extreme remedy to ask a judge for.
I have asked for that twice. And the first time, the children were so old, and the judge said, you know what, the age of these kids and the way they were so disrespectful in their testimony to the court, the judge said, you know what, he goes, I'm going to get reversed for this, but I don't know if it'd be best to even put the kids with dad because of their ages and the level of alienation. He said, but you know, I'm gonna cut off all your child support. There has to be something there. And I have a case right now, a very high conflict case where, you know, I've asked for the mother to go to jail. I've asked for we've even said, you know, it'd be better for the kids to be in foster care right now than it would be for the mother. But unfortunately, some of the judges who aren't versed in alienation, the courts are not prepared to handle such high conflict cases. And not to use the word narcissist, I just said not to, but sometimes family court can be a narcissist playground because they come in and they can just manipulate the system because, truth be told, even though they're the family courts, they're not equipped to deal with such high levels of alienation that the courts just don't know what to do.
Yeah. Yep.
Right. Okay. So, Dave, what to do when the judge denies a GAL, denies child interview, and denies CPS records, which goes against Rule of Evidence 803, the business exception to the hearsay rule?
I'll start at the end. I don't know that CPS records would be a business record, but I think that's a good argument. They may be, and you could probably get them in that way. You know, this is the thing. We've had some judges that have said, I'm not going to listen to the children. I don't know that they can do that. I think you can call any witness you want. Right. I mean, you got to weigh the options, but I don't think they can just carte blanche say you can't call that person as a witness.
That's right.
And so I think you just have to talk to your attorney. How important is it that you get that child in there to testify? I think you could push that issue if you needed to.
I agree. Brian, how do you force a GAL to write a status report? It's been over 3 years, and I have asked many times.
That's a long time.
It's a long time, but I don't think that you necessarily can force them to write a status report unless the court orders such, or you have to look at your statute and see what the responsibilities are of a GAL. I don't know that you could force it. Can you, Kevin?
I don't think you can force it. I've a lot of the ad litems that I've dealt with around here, if we ask them, hey, will you kind of give us, we call it a halftime score, like kind of where are we? Sometimes they won't, but a lot of times they will. They'll give us an idea.
Yeah. All right. If the judge already has made comments during the trial, such as the writing is on the wall, sir, one of you is not getting 50-50, sir, how do I believe that the judge will even consider or use my son's interview for the decision? I know that my son has told the court he wants to be with me multiple times, but no one monitored it on the record.
I know what my son told me. No one mentioned it on the record. Well, if the child didn't testify, then
on the record, my bad.
Yeah, I don't know that you could get it on the record, but if the judge is saying that on the record during the hearing, I mean, that's a problem. That's almost like he's already making up his mind, and that's an appealable issue. I mean, that's a major appealable issue.
And I would go look at your state law, because I know that, like in Alabama, it says that if a party asks for 50-50, the judge has to consider that. So that would clearly, I think, show enough bias where you could file a motion to recuse that judge, because the judge is saying, look, I don't care. I don't care what the evidence is. I don't care what your kid says. I'm not doing it. So I would think that that would be a good motion to recuse, but check your state law. And on the issue of a court reporter, there's some judges here that won't have court reporters. I know that up in Jefferson County up in North Alabama, you have to bring your own court reporter. You have to pay for that. But you can file a motion for a court reporter to make sure that everything that you said gets on the record. And Kevin, I'm sure this happens to you sometimes, but sometimes the judges will say, okay, let's go off the record. Mm-hmm. And I say, no, I think we'll stay on the record. So the judges don't always like that. But sometimes when they say, let's go off the record, something is about to be said that could affect the outcome of your case or affect the outcome of an appeal. Kevin, what do you think about that?
The judges I deal with in Arkansas are very good about keeping everything on the record. It is rare that they would say, let's go off the record for a minute. I can't remember the last time so I fortunately haven't had that issue, but we always have court reporters too. Every county, every hearing is going to have a court reporter.
I got you. All right, we'll take one more question. I know we're over an hour right now, and you guys, there's a ton of questions we didn't get to, but let's see what Robert has to say. What do you suggest when opposing counsel is supposedly non-responsive and my attorney has not filed a motion for the court to sign order appointing amicus, like she said she would months ago? I'm afraid to push too hard, but my case needs to move forward.
I think you mean push too hard with your own attorney. Mm-hmm. Your attorney works for you. It's not the other way around. And you're paying them to work for you. So if you've got questions, you need to ask them. Anything that you've got that you want to ask. And I know attorneys can be intimidating to non-attorneys, but that's a relation. You guys are on the same team, and you need to be able to communicate. And if you're having issues, and it's been months since you've asked for something to be filed, that could be an issue. You need to go talk to them.
Absolutely. And understand this, you guys, for the most part, the family court judges have a ton of discretion. They have a lot of discretion, but they can't rule on what's not in front of them. Right? So sometimes you say, well, gosh, I've been getting with my attorney, but my attorney won't file this. Then you put in writing meet with your attorney, figure something out that gets on the record. Okay. Because ultimately, and Kevin, I know you do this too, but when you put these cases together, when you go to trial, ultimately is what you're doing is you're building a record for the Court of Appeals. Because when you appeal something, too many people think, well, I'll just go to the Court of Appeals and then I'll submit all this evidence. You're bound by whatever is in that record. That's all the Court of Appeals can look at. So Kevin, give them one last bit of advice here. When they're going to court, what is their goal as far as presentation of evidence?
You've got it. That is your time to present everything. And you've got to make sure you've got all your witnesses. You've got to make sure you've got all the documents and all the evidence that you want to use. And because that's true, if you don't prevail, you want everything in that record so you can use it if you have to, unfortunately, if you have to appeal your decision.
Absolutely. All right. Well, Kevin, thank you so much. It's been fun. I'm sure we'll do this again. And you guys, I'm sorry, there's a bunch of questions that we didn't get to, but come back. We're going to try to do this, on a weekly basis and get all your questions answered. It was good to see everybody again. Good to see your comments again. And we'll see you soon.
Thanks, Melissa. This was great.
Thank you for joining us tonight. We are fighting for the rights of parents worldwide. If you want to help support our podcast and for us to continue this mission, please join us at patreon.com/dadtalktoday. You will find us on Facebook, YouTube, Instagram, Twitter, CloutHub, Parler, iHeartRadio, Stitcher, Spotify, the podcast app, Google, Apple Podcasts. We're a little bit of everywhere. And guys, every time you like and subscribe, you help us continue this mission. Thank you, and we will see you next time.
I thought that went great.